enter into mediation mechanism, unless for several type of dispute. Yeah, for example, for the competition dispute, business competition dispute, or bankruptcy dispute, or payment obligation suspension dispute, or we call it the PKPU. Yeah, other than those specific dispute, then it is mandatory for both parties to enter into mediation process before continuing the legal proceeding, before examining the merit of the case, before cross-examining, before submitting any further documentations. So that's the first type of the mediations under district court, and it is mandatory. The second is optional for the dispute settlement as an alternative dispute resolution mechanism. Yeah, it is optional unless if the parties have agreed in this contract, in a contract, they will settle the dispute through the mediation first. For example, in the construction, in typical constructions agreement, where typically they have some sort of dispute avoidance board or dispute avoidance mechanism, that before the parties enter into litigation process, they have to enter into mediations mechanism. So other than there is a specific regulation or specific provisions on the mediations in the contract, then mediation is an alternative in an optional things. Yeah. These are the difference. Yeah, I just want to slightly show you the difference between the mediation under the district court and the mediation under the RDR, or under the arbitration and RDR law number 30, 1999. For the district court, the institution is district court located in each regency and cities in Indonesia. In RDR, there is non-institution based, or we have here the institution of mediation center. We call it PMN, Pusat Mediasi Nasional, or Indonesian Mediation Center, or in BANI, Indonesian Arbitration National Board, because in BANI is actually arbitrations, but the arbiter will encourage the party to enter into mediation and settle amicably. And the durations basically almost the same. The mechanism in the district court, 30 days. It can be extended for another 30 days. But a typical mediation in district court, straight away 30 days. If there is no development, if there is no settlement between the parties, then the judge will cut the process and continue the proceeding. Yeah. And in RDR, the period is 30 days. And the mediation fee in the district court, we have two types of the mediator. The first is non-judge mediator. So the parties agree to use non-judge mediator. If the parties agree to use non-judge mediator, of course, there will be a separate fee to be agreed by the parties. But the second type is that the mediator will be the judge. Yeah, and if the parties agree to use the judge, yeah, as the mediator, there won't be any additional fee for the mediators or the mediation process. In the RDR is private mediations actually, and practically the fee are calculated based on hourly basis. Yeah. For example, in the PMN, Pusat Mediasi Nasional, is provisions that the minimum mediator fees for 2.5 million per hour, or is about 160 US dollar. Yeah. The mediators in RDR is institutionalized or as agreed by the parties. In a court, it can be judge or it can be other certified parties. So the key is as long as the mediator is certified mediators. The procedure in district court, the mediation rules are prepared by the mediators and the parties. Yeah. And the confidentiality status, yes, it is confidential, like private mediations we have. And each party must attend the mediation proceeding in person. Yeah, there is a specific provisions in the PERMA, in the Supreme Court regulation, saying that the principal must attend the mediations in person, unless for several reasons, yeah, health conditions or under guardianships, it can be represented. But however, practically, in day-to-day mediation practice in district court, the parties, the principal, may be represented by their legal counsel. Yeah, and the venue in district court can be in the courtrooms, yeah, or in outside the courtroom if the mediator is a non-judge mediator. The product is almost the same. In district court, we call it akta vandading or settlement agreement, kesepakatan perdamaian. And in the ADR, there is almost the same formula, the same format, perjanjian perdamaian or settlement agreement. Nature of the product, settlement agreement, as long as it is registered in the district court for the ADR and for the district court, automatically it will be binding upon the parties and it cannot be appealed to the next level. So that's the distinctions between the district court mediation and ADR mediations. We have here the mechanism of mediations under the Indonesian arbitration and ADR law. The first is direct negotiations, which is not involving the mediator here. If successful, then mutual written agreement. If it fail, then to the next stage, internal mediations. Internal mediations mean both party, the disputant, appoint a mediation which is not coming from an institution. It can be from private, it can be a lawyer or professional. Again, if it is successful, then signing a final and binding settlement. If it is not successful, then it goes to the third stage, which is external mediations. External mediations basically that the mediators appointed by the litigants, by the dispute parties, is coming from the institution. It can be from PMN or can be from the from BANI. If again, if it's successful, then the parties enter into a settlement agreement and register it to the district court to get the final and binding status. But if it failed, then continue to the normal litigation proceeding, whether it is court or arbitration. This is the time frame from direct negotiation, 14 days, direct the internal mediations 14 days, and the external mediation is 7 days. This is the formative, the normative mechanism stated in the arbitration and ADR law. But however, in the practical, the parties actually is free to set up whether they want to jump in directly appointing external mediator, appointing a mediator from institution Indonesia, or directly go to Bani, for example, and they appoint a mediator from Bani. That's actually uh, based on mutual agreement between the parties. So yes, it is regulated under the Indonesian law ADR, but in practical, a party free to directly jump into the certain stage. It's not necessary to be stage one, stage two, stage three, stage four. That's the general overview for mediation based on the Indonesian arbitration and ADR law. And now, and the general overview on the mediations through district courts. Like I said before, in Indonesia, before proceeding continue, examining the merit of the case, respond, examinations, the judge has an obligations to order, yeah, to instruct the disputant, the litigants, to enter into mediations process, yeah. Uh, so this is the thing. If the plaintiff is not present, the district court will revoke both party present next to the second stage, yeah, and then the judge will offer you, yeah, an option whether you want to appoint a mediator, but actually the mediator is a judge, yeah, active judge in the relevant court, or the parties prefer appointing non-judge mediator. So at the first hearing, the judge will offer the disputants, will offer the parties to opt whether you want to use a mediator from the judge or non-judge mediator. And like if you appoint mediator from the judge, then there won't be any fee. But if you appoint non-judge mediator, there will be a separate additional fee. Then come to the mediation proceeding. Uh, uh, if successful, then the parties will sign a settlement agreement. We call it in the Dutch language Akta van Dading, or Akta Perdamaian. And if the party fail to reach an agreement, then the trial will be continued to the next stage. Yeah. And the maximum period from the first hearing until the mediations ended is 30 days, but it can be extended for another 30 days if both party feels they need longer time to discuss. Yeah, but it's subject to approval from the mediator, from the judge. Yeah, because the judge sometimes will see, okay, we make some progress here, and maybe we need some more additional time, or the mediator judge will say, okay, we don't have any progress here, and your proposal to extend the 30 days has no basis, and let's continue to the merit of the case. So that's basically the commercial mediations mechanism in Indonesia through district court. Next is on BANI. In BANI, based on BANI Procedure Rules 2020, uh, if there is arbitration clause in the agreement, then you enter into a BANI proceeding. Before start that BANI, the arbiter will encourage you to reach amicable settlement, whether independently, there's no involvement of third party, or through third party assistance. It can be mediation, it can be conciliations. We talk about mediations. If the mediation failed, then continue to the matter of the case. But if the mediation is successful, then there will be amicable settlement award. The award will be considered as the arbitration award. And for the execution, it will have to be registered in the relevant court. So that's the mediations based on BANI rules. Now I go on the data we obtained. How successful is actually the mediations in Indonesia? We have two types of numbers here. The first is the mediation in the court, yeah, in the court in Indonesia. We tried to have a data from the Supreme Court as to the numbers of mediation, but unfortunately we failed to do so. But we have a data from district court in Semarang. Semarang is the capital city of Central Java province. Yeah. We have a data from 2013, 2014, 2015. We have 479 cases for 2013, 2014 to 492, 2015 520, and the successful mediation in Semarang, actually in form of numbers, still very low. In 2030, only 5 cases is resolved through mediations. 5 cases representing only 3.2% from the total 479 cases. In 2014, only 8 cases. In the more percentage is getting lower. It's only 1.6% from the total 492 cases resolved through mediation. And 2015, only 7 cases out of 520 cases, or only 1.3%. So I think from the percentage here, from the number here, we see that the mediations in the Indonesian court is not that successfully resolving the dispute amicably. So maybe we can discuss why in the later on slide. Yeah. So now we compare to the data we obtained from PMN. PMN once again is Indonesian Mediation Center. It's a private entity. Actually, it's not government-owned entity. Yeah. But the data we obtained is only the reported data. What does it mean? Actually, it's not all mediators in PMN report the case that he or she handles. So it's only the reported data. Yeah. There are two types of mediation handled by the PMN mediator. The first is the mediations in court. Yeah. When the dispute in the court, and then the parties agree to use non-judge mediators. So is the data from 2004 and 2000, until 2018, 14 years data. But I think that from the numbers, not so convincing, because there are only 53 cases for 14 years, yeah, reported. It is accepted by PMN. And out of 53, 46 is mediated, and 13 successful, and 3 partially successful. Partially successful means, for example, there are 3 or 4 parties in the dispute, and the agreement only between 2 parties of them. So it's not entirely covered all the parties. It's only 30%, but the number is much higher compared to the mediation, the successful mediation in court. Yeah, because it's 28.3. Outside court mean the parties directly come to PMN to ask an assistance of mediations. From 61 accepted cases, the mediated 29, the successful mediation is 24. From the number is very convincing, but again, the data is based on the reported cases. It's not all the cases. So in terms of numbers, it's 82.7%. The accepted cases in PMN is successfully resolved through mediations. So based on these two pictures, we understand that the successful rate in the PMN or in other private institution is much higher compared to the successful mediation rate in the court. Yeah. So that's something that we need to learn further, how that could be that the difference between the successful rate in court and PMN is quite bigger. And next to the mediation in specific sectors, yeah. For the first is on the construction services. The construction services is based on the Indonesian construction law. The first is internal negotiations, and then if internal negotiation means directly between the parties in the contract. If there is no agreement, then it goes to dispute settlement board or mediation. Yeah, it depends on the agreement, the provision written in the agreement. Yeah, if the mediations fail, go to conciliations. If the conciliation fails, then to go to the arbitrations. The same way, if dispute settlement board fail to reach an agreement, then go to the uh, uh, arbitrations. In Indonesia, there is alternative dispute resolution for the construction services. We call it Badapski. It's a dispute resolution body in the field of construction. It provides services, yeah, like arbitration, consultation, negotiation, mediations, conciliations, and expert appraisal. But somehow the use, yeah, of Badapski is not so popular, even though it is stated clearly in the regulations, in the law. It is as one of the dispute settlement forum. But the parties tends to use again arbitrations with the local or international, or directly to the court. That's the mediation in the constructions. And next on the employment, yeah, in the employment, mediation is also mandatory in Indonesia. Like you see, in Indonesia, for the industrial dispute, you have to go to mediation first before you can submit your claim to the PHI or industrial court, industrial relation court. Yeah? So the mediations will be proceeded, yeah, and If it fails, then the mediator will issue recommendations, and the recommendations can be used as an evidence in the court proceeding in the PHI. It's a bit different with normal mediations.
Yes, thank you, Mr. Denny, because 20 minutes so fast. We
Oh,
need to end this first session first, and then we have to quick polling only
okay.
for 2 questions for the participants to answer.
Okay, so do I have still time to finish my presentation or?
Maybe we can give you 5 minutes for closing.
Okay, thank you, Praniti.
Yes.
Okay, I think for the closing, yeah, advantage for the mediations, I think Pak Basul Azab will discuss and explore further on this. And obstacle of mediations, I think the Pak Basul will explore further, but it's only a note from myself. The first is the obstacle is especially in the court. Mediation is only a formal requirement in court mediations. Yeah, it's not managed properly. Sometimes, as a litigator, uh, during the mediation process, we are not focusing on the mediation process itself, but we are focusing on preparing the documentation of the response to the claim. Yeah, so because it's a formal requirement only. Second is inadequate planning and preparations. Both party has no adequate planning and preparation before entering into mediation's table. Impression and perception during first session may mislead. Sometimes when we firstly come to the mediation table, which are the gap of understanding between the parties is too big. It's impossible to resolve this. Let's do the litigations. Or winner takes all mentality, overconfidence, wrong baseline. Yeah, sometimes when someone start litigation or start thinking during the litigations, they have the winner takes all mentality. Okay, if I win, I can get all the recovery. Yeah, and overconfidence on the case he or she have. Failure to listen and respect the counterpart's arguments. Yeah, too much emotion involved during the mediations. And this is very important. Number 7, skills and experience of a mediator. I think these are the thing as obstacle in successful mediation in Indonesia. I think that's I can share for the introduction of today's webinar. Maybe we can move up to the next speaker, Pak Basul Azab. I come back to you, Praniti. Thank you.
Yes, thank you, Pak Dendi. As we have heard that there are lots of differences between mediation, arbitration, and going to litigation in Indonesia. And now we will take a quick polling for our first session. And the quick polling will appear on your screen. We will give you 1 minute to fill it.
Sudah mulai kah ini, Mbak?
Okay, the quick polling session is end. And now we are ready to enter the second session. It's about seeking resolution, strategies in mediation and settlement by Mr. Bazul Azab, the managing partner and head of dispute resolution at Oon Bazul LLP Singapore, a mediation ambassador to Indonesia as IMC. Please welcome Mr. Bazul. How are you?
Thank you. Thank you for the introduction and for organizing this wonderful seminar. Good afternoon, everyone. Thank you for attending. Now, I hate the dispute resolution practice, which means that I resolve disputes. Having done this, and I do quite a bit of cross-border disputes, having done this for a long time, I fully appreciate from the commercial man's perspective the need to work out the most quickest, cost-effective way to resolve dispute rather than on all occasions getting judgment published so that interesting propositions of law can be ventilated for the benefit of lawyers. Now, this is where mediation comes in. I am a true believer of the benefit of mediation. And I'm seeing an increasing number of cases which are now settled through mediation in Singapore and through SIMC. Now, mediation, at the very least from the Singapore's perspective, has taken a significant seat as an important dispute resolution mechanism and no longer seen as a poorer cousin of arbitration or litigation. Now, the significance of the acceptance of mediation as a serious tool for dispute resolution is evidenced by the introduction of the Singapore Convention on Mediation. Now, the convention applies to settlement reached through mediation, which are concluded by parties to resolve a commercial dispute. The convention has 53 signatories and are now ratified by 6 countries. It's already come into force of law. The convention provides an efficient and harmonized framework for cross-border enforcement of settlement agreements resulting from mediation. So now you can enforce your settlement agreement reached through mediation as though it is a court order. Now, I'll elaborate on the Singapore Convention on Mediation slightly more later. Now, before we speak about the benefits of mediation, what we need to do as a community is to deal with the perceived problems or weaknesses. Now, I saw the poll earlier. The poll suggested that 48% very likely to go for mediation, 48% likely to go for mediation, only 3% unlikely. So I think I'm preaching to the convert, but I will try and move those who are likely to very likely and probably change the mind of those who are unlikely to mediate. Let me touch on the first myth which surrounds mediation. I hear this often from the commercial man. Proposing mediation is a sign of weakness. Would it send a wrong signal to the opposing party? I say to my clients, that is not true, because if you have a very good lawyer, commercial lawyer, and on a commercial matter, he is not going to say to the client that just because a mediation is proposed, it should be treated as a sign of weakness. Now, the lawyers have a duty to their client to see that the matter can be resolved amicably without the clients expending substantial time and cost. Now, if you still perceive that there may be a perception of weakness, now you can then present the proposal. There are ways to present it. Now, one of the methods which I adopt is I spell out the weakness of the opposite party in my request. And then I explain why it is the interest of both parties to avoid cost and time in resolving this dispute. Now, I also take advantage. What I do is timing for mediation is absolutely important. So what I may do is after a tactical victory, say, for example, if I take up an application for discovery, if I win that application, then from a position of strength, I say to my clients, although you have won this round, you have won the battle, you have not won the war yet. Now is the time for you to propose mediation from a position of strength. Now, in some jurisdiction, to take away the stink of the suggestion that proposing mediation is weak or smells weakness, some of the courts have made it compulsory or at least quasi-mandatory to mediate. So, for example, you heard from Pak Dendi that Indonesia it is mandatory. In Singapore, England, Hong Kong, you will have to take a serious request for mediation seriously. If you don't, there is going to be consequences, even if you win. And in Singapore, it is the Singapore Mediation Center which sends out a letter to both parties, inviting parties to mediate. So it takes away the need for parties to put in a request for mediation. Now, myth number 2, mediation is a delay tactic used by parties with weaker cases. Now, that's not true. Now, you heard from Pak Dendi as well, that in Indonesia, there's a strict timeline for mediation. And that's also true, even in private mediations. So I actually like to set strict timelines. So I generally work around 2 to 4 weeks to get the matter mediated. Now, there is also a framework which you can agree to for the mediation to be successful. So you can say that, if there is a particular person, not just persons who have the mandate to agree, that's a given. If you don't have mandate, or rather, if there is no mandate to settle, then there cannot be a mediation. So the person with the mandate must turn up. Now, you can also assess, beside mandate, would there be any other persons who would be useful to turn up at the mediation so that his view can be tested as well, so that his view may be important to reach a settlement. This may be a patriarch who may not be a director of a company, but is given substantial respect. Now, if there are no defenses to a claim, you could also ask the other party, why don't you set out a rough framework of settlement so that I can have an idea before I go for mediation? These are methods which you can avoid a delay. Now, there's also that myth number 3. There is also the suggestion that mediation may be ineffective. My own view is that it is far from the truth. Now, mediation, my own experience, I have about 75% rate of settlement in the mediations which I conduct. I conduct about 5 mediation, and it's increasing year after year. The number is increasing as I'm seeing more take up on mediation. Now, SIMC, which I mentioned, has also published their own data, their overall success rate. That's about 80%. Now, so mediation is not ineffective. And also mediation does not just involve small cases. Those cases which I mediate are worth tens of millions of dollars, if not more. You heard from Pak Dendi that the Indonesian court-led mediation is not very successful as compared to a private-led mediation. Now, I have experience in court-led mediations as well, not just in Indonesia, but in Philippines. It has the same sort of a structure as Pak Dendi set out as well. Now, the reasons, I have my own reasons why this happens. I mean, in fact, my friends from Korea, Japan, and India, in fact, there are also court-led mediations in those jurisdictions. Maybe we can test their view later. Now, court-led mediations, my view, my experience is not very effective because the judge is not trained to carry out a effective mediation. Now, a judge is just there to tick the numbers. So it's a process. You need to go through that process in order to have the matter progress to a court litigation. So what he does is he quickly disposes it without understanding the techniques which is required, which would be applied by a professionally trained mediator, which is why I think it leads to a low settlement. Now, mediation, as you know, I spoke about the Singapore Convention. In order for a mediation to be effective, there must be teeth, there must be bite. Now, with the Singapore Convention, you can enforce an award, or rather a settlement, which is reached through an international mediation, which takes place in one of these signatories to the Singapore Convention and to be ratified in another convention country. It can be enforced just like a judgment. Now, US, India, China are one of the larger signatories who have signed, but not yet ratified. Singapore, Saudi, Qatar, Fiji, Belarus, Ecuador has ratified it. So it has force of law within those countries which have ratified at least. I am hoping that more countries will ratify it. I suspect the delay was caused by the problems COVID has brought to us. And I'm hoping with more countries seeing the sense behind mediation, I hope eventually, not immediately, eventually it will be accepted as the New York Convention on Arbitration, which has 168 contracting states. Now, even if mediation doesn't lead to settlement, mediation can assist in narrowing down issues. Now, I'll tell you my experience is I had a matter which has 15 complex issues, and some I thought was entirely irrelevant to determining the real dispute. I thought the lawyer is just throwing in the issues so that it gets complex. No, because with the cooperation of the mediator, we actually managed to narrow down the dispute to just 2 core issues, which were resolved through litigation. You know what happened was, instead of 15 issues, which would have taken a trial of 20 days or more, we managed to finish the trial within 3 days because the issues were narrowed to 2 issues. So there is, and significant cost would be saved because of the narrowing of the issues. Myth 4. Now, mediation can be used as a tool to obtain improper discovery. Now, I'm telling you, that's not going to happen because you have excellent lawyers. Your lawyer is not going to allow anyone to bully you into giving discovery. And the mediator is a facilitator. He has no power to order discovery through the mediation process. Now, I'm going to touch on what sort of preparation you need to have in order to reach a settlement. Now, so what a trained mediation counsel does is, unlike in litigation is adversarial. You marshal up your legal arguments, you go into court, you persuade the judge. Whereas in a mediation, what you are trying to do is figure out the common interest. So what I tend to do is I'll find out who the decision makers are. Their interests, background, LinkedIn, these days you can find much in the social media. So I will get an idea of how they think. Then I would see, are there facts in the case which will, cause a reputational stink if it was to go on. So then I will tailor my presentation technique in order to deal with the psyche of the opposing party. Now, I generally don't speak to the mediator, unlike a judge. A mediator is a facilitator. So what I do is I speak to the client on the opposite side. I find this to be excellent. I get an opportunity to convince the other side, client, to see the sense in what I am trying to propose. And I find it interesting that human nature is such that it You can be unreasonable over the phone. You can be unreasonable over email. It is very difficult to be unreasonable when you are in a face-to-face meeting and when someone is saying to you that your position is completely illogical and you are unreasonable. Generally speaking, people find it very difficult to be the unreasonable one. So I use that quite a bit. Now, is it all about monetary objective? Court may well be, but not in mediation. In order to understand this, let me tell you a real life example. I was acting for a bunkering company in Singapore. We sued an ex-employee director who misappropriated money. His defense was that the way my client conducted business was improper. I investigated and found out there was no truth to the allegation, but unfortunately at the time, there were many bad hats in the bunkering industry. So the regulators were revoking licenses left, right, and center. So I thought, my God, even if I succeed in this case, my client's reputation will be tarnished by the time the case takes about 1.5 years or so. And there is a danger that may well be a bigger blow to them than the several millions the director has misappropriated. So what I did was this. I made a police report against the employee director, took up an injunction, and immediately requested for injunction, a Mariva injunction, because obviously there's fraud. And then asked the opposite side whether or not they're prepared to mediate. Through the mediation process, I achieved a 70% settlement of the claim. I also got a settlement award, which said that if they fail to pay the claim, I can go for the full claim. I got a second mortgage on the property, work out an installment plan, and I also sought a public apology, withdrawing the allegation made. You see, this I would not have been able to achieve if I had gone through, or the clients have gone through, a litigation in court. So as I mentioned before, it is important in a mediation that the clients take the central role. So in an open forum, the mediation process. So we usually have an opening where I speak, my opposite side speaks. Then in some cases, I have the client speak, because sometimes it's important to have any grievances which the clients have to air out, so that each party can understand what is the true reasons which are blocking a settlement. Now, it is interesting about the psychology about mediation is extremely interesting. The Hawthorne effect is used to describe changes in personal behavior. So there are several methods to extract what the true intent is. Indirect procedures, where I test after listening to the parties what statements, and then I test back whether or not I set out the interests which they have set out, paraphrase it, and then see whether that takes a bite. I may also give in hypothetical situation and then see whether that may gain tractions. You may also be able to use the mediator to go through parties in a shuttle diplomacy to assess what is their true intent. A good mediator would be able to do that. My personal experience is this. Many times parties conflate their position such that the true reasons behind the dispute is lost. So I give you an example, right? And this is an example often given. Two children fight over an orange. Child A, and you need to find out, and after finding out, you say child A wants the orange peel in order to bake a cake. Child B wants the orange to make orange juice. There you go. You then know how to separate the orange. Let me give you a commercial example. Two business partners fighting over ownership and control over a company. Now, and they are children of the father who started the company. Party A, the son A, wants to continue run, and he's ambitious and he wants to expand the company. Son B, little interest, he's more interested in buying cars. As long as he gets money, it's fine. Once you assess the true objectives, what you need to do is you need to allow party A run the company without hurting party B's ego. One of the real problems which happens is if party B's ego is hurt in the sense that you play him out to be a lazy, incompetent fella, that's the end of the mediation. So that needs to be taken on board. Now, culture plays such an important role. Hofstede, there's a website, you can have a look at it. You can assess whether a particular culture gives emphasis to individualism or collectivism. And from that, you would be able to assess whether how to sell, how to present your case, whether whatever you're presenting would be accepted as rudeness, and when you are listening, and of course, my friends who would be discussing in the panel, sometimes when someone says, and this is, I find it extremely unique, the English language. When someone says yes, he doesn't mean yes, he actually means no. It all depends on how he says yes. Is he just acknowledging, yes, I hear you, or yes, I actually believe what you're saying and I'm accepting what you're saying? So that requires an analysis, understanding of culture. So one of the things I want to say, and I will expand this when I'm having the panel discussion, it's important to work with the lawyers which you are, in your local jurisdiction, which you're already familiar with, even when you are
Mr. Bazul,
2 minutes.
unfortunately,
In fact, 1 minute.
Okay, 3 minutes left. It's
No,
okay.
1 minute is fine. So,
Okay, 1 minute.
So you stick to your lawyer because your lawyer in that particular jurisdiction, like Pat Dandy, would have familiarity of the cultural nuances. So even if there's a mediation in Singapore, I rather work with Pat Dandy because then it's useful with the knowledge of cultural nuances. When we work together, there's a chances of settling your case a lot higher. Have I finished the 1 second? 1 minute?
Maybe 2 minutes more. It's okay. But
No, I never use up time just because I have to use up
Okay.
time. I finished my
Okay.
speech. Thank you.
The 1 minute sense. Okay, that's a very incredible explanation because that's a very huge question that if it's the mediation award or the mediation settlement is enforceable, but the fact is enforceable because that's a huge question with among the business executive or the lawyers. Thank you, Mr. Bazul Ashap, for the explanation. And then we are going to show you the quick polling for the second session. And the quick polling will be appear on your screen right now. And we will give you 1 minute to fill it out. Okay. And now the polling session is on. And take a look at the result. Mediation will still show signs of weakness. The participants have their opinion that even though the mediation has enforceable in the countries that has ratified the convention, but still show signs of weakness. But it's okay. Maybe we can. Now is the final session or the third session is a panel discussion about cultural dimension of mediation in cross-border dispute resolutions. And we will be having Madam Varuna Bandari Guknani, a senior mediator in Supreme Court Mediation Center, India, and Mr. Tomoki Yanagisawa, a partner at TMI Associates, Japan. And the third panelist, Mr. Scott Lee, an attorney at Kim An Chang, South Korea. And we are please welcome the three guest speakers, and Mr. Dendi and Mr. Bazul will be joined as a co-chair to the panel discussion. So the 5 guest speakers will have discussion about the mediation in the cross-border resolutions. Welcome, everyone.
Thank you, Praniti.
Yes, now we can start the discussion.
Yeah, I think I am and Basil will chair this panelist discussion, and I'm given a first opportunity to raise the questions. I think it's very general questions. Is mediations mandatory in Indonesia as a dispute resolution mechanism for commercial transactions before entering into a formal litigation proceeding in your country? Maybe the first, I'd like to have your view on this, Yanagi Sawasan.
Hey, thank you, then. Yeah, so my name is Tomoki Yanagisawa. I'm a lawyer in Tokyo, Japan, and thank you for having me on this panel. So to answer your question, so in Japan, mediation is not mandatory to commence litigation, save for a very limited exception, which is the rent review case. So the short answer is no. And I would also mention that under the law, court has discretion to refer a litigated case to a mediation if it deems proper. And that often happens in the field of construction or other, say, some medical malpractice cases that involve technical knowledge. But on any other, I would say, commercial disputes, it's rarely that the case will be mediated.
Oh, so in Japan, mediation is not mandatory before the party entering into litigation proceeding, yeah?
That's right. It's not mandatory.
Okay. Scott Lee, how's your view on this? How about in Korea?
Yeah, thank you very much for inviting me here. And I learned a lot from Mr. Dendi about the Indonesian practice. That is very, very good for me because in Korea, mediation is optional, except for family court. The family court, you have to do the mediation first, but the other commercial matters is only optional. However, in the past, Korean courts lay a judgment quite quickly, but during the last couple of years, it's a delayed. It's getting longer and longer. So we have a lot of a need for the mediation as a quick solution of the case. Let me give you some idea. Let's say the judge will think that this case can be mediated easily, then he refer the case to the mediation. And then judge does not intervene any of a mediation process. So separate mediator run the process. And about 25% have a successful rate of a mediation. So entire case, 20% is referred to the mediation. Among them, 25% is the successful rate. So entire big picture is not that big portion, but still we believe there's a huge potential. So there are a lot of activities going on in South Korea because we need a mediation more. So as an infrastructure, there could be a legislation, there could be some education and training program. I learned a lot from Indonesian practice.
All right. Thank you. Thank you. Mrs. Varuna, how about India then? I think you're still muted.
Yeah, thank you very much for inviting me to this forum. And as we are aware that there is a lot of delays when the matters are in litigation, and in India, as the country is developing, so they are very open to having pre-litigation mediation. So as in 2015, there was a judgment whereby the Supreme Court directed that there should be pre-litigation mediation desks in all the court annex mediations. So we have two kind of court annex mediations. One is when you go to the court and the parties are before the court in a court case, and then the matter is referred to mediation. But there are other cases where the parties just approach the mediation center, which is next to the courts, and they put their cases before the mediation center. Each mediation center has a panel of mediators. So the parties are not open to choose their mediators, but the mediation center, which they think appropriate on the subject, and then the mediation takes place. Whenever a settlement is arrived at in this mediation center, there is a stamp of the court. And in this pre-litigation mediation, the enforceability is not difficult because it has a stamp of the court. And sometimes the other court annex cases, as Mr. Lee just said, that the matter goes to the court and the matter is sent for mediation. That is the other way of doing the cases. There also, there is a stamp of the court. So the execution is not a difficulty. Then there are private mediation centers and government mediation centers which have come up, which have a scope of pre-litigation mediation. But we do not have any law to say that you have to first go for mediation and then go for litigation. That like I will touch on that topic at a later stage, but as of now I will restrict myself to court annexed mediation, where we have a pre-litigation desk and court annexed, plus we have private mediation centers where the parties, if they have a mediation clause in their contract, can approach. And for the enforceability of these private contracts or private settlements which have been arrived at, we take the help of Arbitration and Conciliation Act, as the process that is followed is mediation, and outcome is a conciliation award. So the conciliation award is enforceable under Arbitration and Conciliation Act. So this is how we are doing pre-litigation mediation in our country. And the government, furthermore, is also very interested in pre-litigation resolutions. So in their government is the major litigant in our country. So for the disputes which are with regard to government contracts, they have dispute resolution committee. So whenever there is a dispute, the matter is referred first to dispute resolution committee, but then this is an in-house committee. So you have to have that kind of confidence in the process, and which can then go for, if not possible settlement, then it goes for litigation. Thank you.
Perfect. Thanks, Mrs. Varuna. I think before Bazul will continue to the next questions, I think I have one more questions. Is mediation trending as a dispute resolution mechanism in each of jurisdictions? Is there any specific industry or specific sector that use mediations as the most preferable dispute settlement mechanism? Like in Indonesia, we have a construction, for example. Is there any that kind of specific industry or sector that use mediations? Maybe for the first time, I'd like to have a view from Mrs. Godley, your view on this.
Yes, the specific area, perhaps I have to tell you that in Korea, we have a lot of dispute resolution centers. The government agencies and ministries wants to set up a dispute resolution center a lot. Some people even criticize that there are too many. In fact, some dispute resolution center simply do not have many cases. Quite recent one that attracts a lot of attention is that my voice is okay?
Your voice is perfect.
Good. Medical malpractice dispute resolution center. That attracts a lot of attention because medical malpractice dispute requires a third-party neutral, scientific review of the case. So it has a particular function of that. So that one receives a lot of cases. And we have a software dispute resolution center, privacy dispute resolution center. Of course, we have a consumer protection resolution center, and so on and so on.
Okay, so I know from your explanations that the medical is trending, mediation things in the Korea, yeah, from what I understand from explanations.
Mhm.
Mrs. Faruna, how about India?
Yeah. In India, as I would say, it is a dispute resolution revolution that is going on. So as all stakeholders, they have come forward with a multi-layer approach to a dispute resolution. So first and foremost, they want to go for negotiation. In-house negotiation where the parties sit together and negotiate. Then if that fails, they want to go for mediation. And if mediation fails, they want to go for conciliation. And then is arbitration. Now in arbitration also, they want to go for a hybrid of arbitration, where the reference is made to the arbitration, but the process followed is of mediation, and outcome is also a arbitration award. So it is arb med arb. That is what it is happening, and litigation is in the end that they will go for. So in the 2018, there was a 2021, there has been a judgment of the Supreme Court whereby a criminal case of a check dishonor or the transfer of money through a bank process, if it happens, the matter can be mediated. So it has to be referred to a court annexed mediation center for mediation. So that is the latest that has been added for pre-litigation mediation. So now other disputes which attract mediation, apart from the family disputes, matrimonial disputes, or other disputes, are the Companies Act. Any dispute which comes under the purview of the Companies Act. So there is section 442 which has been added in the year 2013, whereby any dispute when the parties come before the Companies Act, NCLT, that is National Company Law Tribunal, the matter is referred for mediation. Here also we have an in-house panel of mediators who handle these mediations. Then we have Micro, Small and Medium Enterprise Act, that is MSME, whereby again these matters can be matters coming under the purview of these commercial matters can be referred for mediation. There also they can go for court annexed mediation, whereby the outcome is going to be a conciliation award or the stamp of the court as they wish to. Then there is the Real Estate Regulation and Development RERA Act. So where these construction companies, if they have a dispute, they are immediately after they file a complaint, the matter is referred for mediation. Then Commercial Court Act is the dynamic act which came into force in the year 2015, whereby pre-litigation mediation became mandatory. You have to, if you have any matter which is above 3 lakhs or say around $4,500, the matter has to go for mediation first, unless there is a immediate relief that is required to be then they can skip mediation. They can make an application that they want a urgent relief, therefore mediation can be at a later stage or may not be there at all. So India is moving and respecting the mediation in a very big way in all spheres of disputes.
Thank you, Mrs. Varuna. Now, the last but not least, Mr. Yanagisawa. How about in Japan? How do you see the trend of mediation, or the industry or the business sector that now use mediation as business dispute resolution tools?
Okay, so I guess in terms of sector side, it's important to distinguish whether the mediation is used as a way to resolve B2B disputes or more like a B2C consumer type disputes. And in that regard, I think the most predominant sector which uses B2B mediation, so to say, that would be construction, as I mentioned earlier. So in fact, there's a government established adjudicatory body called the Committee for Adjustment and Construction Work Disputes, and which handles it provides mediation services as well as arbitration services. And approximately statistics say about 100 cases a year that they handle and resolve. In terms of B2C type of disputes, I would say financial industries, they have some government or quasi-government-backed ADR centers which handles mediations. So now I kind of found it interesting to Scott's comment that there's a criticism that the government has established too many ADR institutions, and that to an extent is true in Japan. So each industry has some sort of a dispute resolution body which may or may not employ mediation as a tool. But overall, the number of cases that those institutions handle have not been growing. So and that's kind of backed up by the fact that in Japan, private ADR services have not been very prevalent as a means to resolve business disputes. Having said that, as Bazul mentioned in his presentation, we are very mindful of the Singapore Mediation Convention, and in fact, now the government is preparing a proposal to amend legislature related to ADR, such that we will be able to execute a mediated agreement with relative ease, similar to the way an arbitration is enforced under the New York Convention.
Thank you very much your explanations, Yanagisawa-san. Maybe Pak Bazul, maybe you can raise questions related to the cultural aspect of these mediations. The time is all yours, Pak.
Thanks, Pa. It's your questions are very informative, and the answers given by the panelists were really useful. Now, I'm going to touch on the cultural aspects. From a cultural perspective, and basing on your and the panelists' experience, I will ask each one of them for their view. What do you think is or are the common obstacles that you would see which would prevent successful mediation? Well, I'll take that question first before I have another cultural question. Maybe can I start with Mr. Scott Lee?
The question one more time.
Sure. From your experience, what do you think is the common obstacle that you have seen that prevent a successful mediation from a cultural perspective?
Yes, somehow Korean people are emotional, particularly when they have a litigation, they are really emotional. So that high emotion is obviously a negative for the having a good settlement agreement. So what is the solution? Solution may be we have to train the mediator to calm down the parties and then find out the hidden intention, hidden interest. That is highly important. However, at the moment, almost all the mediation is done court annexed mediation. And the compensation to the lawyers are really, really small. It's just lunch money or taxi money. So not many active, competent lawyers are participating in the mediation. But I did. I do, not because of incompetency, but because I want to promote the mediation more to the Korean society. So I'm actively receiving mediation case in the Seoul Southern District Court. So I'm hoping there will be a more training for the mediators, and then we can have overcome the emotions, high emotions of Korean parties.
Very interesting. Very interesting. Before I go on to another panelist, maybe that's something which I want to add on to what Mr. Lee said. It is, I believe that it is so important for mediation to be treated as important and properly funded as though it's a litigation and or arbitration. If parties are not prepared to spend money and think that mediation can be done cheap, it'll fail, because the lawyer involved and the counsels involved and a trained mediator would actually have to spend substantial number of hours in order to prepare through a mediation, as Mr. Lee said. And Mr. Lee, if I have I'm not sure whether you are already a panelist in the SIMC. Maybe if you are not, maybe you should think about. And I will certainly speak to those who are in charge of SIMC. And if I have a mediation where the Korean parties are involved, I'm certainly look to appointing you. And Ms. Varuna, maybe you can go next. You got to unmute. Sorry about this.
So here in this section, I would start with my personal experience as in a court annexed mediation. There was a commercial dispute and Supreme Court referred the matter to me. One side was a Russian and the other side was an Indian. So the moment they came, it was $100 million dispute. And the moment they came to the mediation center, so the parties were really upset. And the Indian party was saying, ma'am, don't worry. I can settle this matter over a vodka. I said, go ahead. Please go ahead and see if you can settle the matter. So they went for a vodka. They came back. So from 100, it came to 65. And the Indian party was crying that I cannot pay more than 35 million. And he's asking for 65. So I started my opening statement because a Russian could not understand English or any other language. So I had an interpreter who could interpret English to Russian. So for me to maintain that balance, that whatever I'm saying is verbatim going to the Russian and to the Indian, he's understanding it, and like there is no communication gap between what I'm saying and what he's understanding. So while I was talking to them, the the Indian said that I had an earlier contract with him of this chemical, and I have the monopoly of this chemical, and he taught me how I had how to export the chemical from the country. So and he has government contracts. So now I shifted the parties to two separate rooms, and that shuttle diplomacy that we say that. I went to the Russian and I told him that, look here, there was an earlier contract where it was executed successfully, and you have more government contracts. Is it a possibility that you can have some kind of arrangement where you can reduce your amount of your claim? He says, no way, 65 is 65. So I spoke to the Indian person and I said, what do you have to propose? He says, if he gives me another 100 million contract, I will give him for the price of the chemical, which was like 5 years back. So I went to the Russian guy. He was already on the phone speaking to his government. So taking a clue from there, I told him that he is ready to give you the contract at that price, which was 5 years early. He will not charge any inflation. He came with a new contract for 40. So now from 65, we were at 40. And then I got them together. I said, well, discuss and sort it out. And it was sorted out. But it got sorted out only for the reason, one, when the opening statement was made, there was a confidence building with the parties that this process is going to help you. And then I had the interpreter to tell me that the communication going to the Russian was correct, and if he had not got that confidence in the process, he would not have settled the matter. He would have just walked away from it. So it is very, very essential that when we mediate, we have to understand the language. Language is one big barrier that we face in cross-border mediations. Then, of course, emotions are run very high. I was shadowing a mediation in Toronto where there was a insurance claim, and the lady was asking for a huge claim for a car hitting her from behind. So the mediator was so sympathetic that you only know how much it has hurt you and everything. Like, he set up as if he was trying to help her, and it encouraged the insurance company person also to follow the steps and be sympathetic to the claimant, right? And the matter was settled for the amount, whatever, she reduced her side and insurance company stepped up and the matter was settled. So emotions, tackling emotions is again a very, very essential thing in mediation, and as we say that it is a ADR. So there is the lawyers feels there is alarming drop of revenue when they come into mediation, because as parties feel that they are not doing as much they would do before a formal court. So they try to pay them lesser. So I think that needs, we need to brief the parties that a lengthy 10 years litigation has been reduced to 90 days. You are in control of the process and the outcome. A mediator is only a person who's assisting you and controlling the process for you. So if they understand that, then the parties will be able to understand the role of a negotiator or their advocate, what he is trying to do. In India, in all our national law universities, we have started 3 courses. One is negotiation, one is mediation, and one is mediation advocacy. So that the lawyers have to have a new stream of advocacy where they don't go into the litigation and courts, while they specialize themselves into mediation practice and negotiation practice. So this is what I have to say on this aspect.
Very interesting, extremely interesting, especially your experiences. So the take home is communication is extremely important, and neutrality is super important as well. So that one party doesn't think that the mediator is only speaking to one side as opposed to both sides. Extremely helpful. Now, Yanagi Sawasan, now we are going to be guided by you as far as what do you think one needs to take into account in Japan?
So I guess just you both panelists has mentioned emotion and language as an issue, and I think that that's probably an issue common to any mediation, regardless of the culture. I mean, you have to have your emotions tempered and be reasonable in conducting discussions. Also, the communications matters very much. So to the extent a party who is joining the mediation discussion is not very capable of whatever the language which the mediation is conducted in, I think everybody needs to be careful that the message is properly conveyed. So to the that those factors are, I think that's universal in any mediation, regardless of the culture. So I guess from my perspective, what I would want to mention that's probably very specific to Japanese culture, especially in the corporate setting, is the how a party makes an internal alignment within as to how to approach the mediation process before the mediation even begins. So as you said, it's really important to have an actual decision maker beyond the sitting in the seat of the mediation to make various proposals and agree on different settlements. And during mediation discussions, the discussion is not just one dimensional. It could go into many dimensions. So say, for example, one party might be demanding disagreeing over how much money should be paid, while the other issue of the the dispute might be how how the say the supply chain should be operated going forward in order to maintain a good business relationship. So it's not just what the authority need to be given to the negotiator at the table must be broad enough. But what I have found in my experience is that the people who actually go to the mediation have not been properly given authority. That's why they need to go back to their boss, their CEO, the board, saying whether they can make this counter offer, whether they can make this kind of concession. And as you know, these kind of like commercial international mediation, they must be concluded in a day, if not two. That's probably the longest. And but the quickness of how we can make decision is, in my experience, has been a factor which, as a lawyer, I need to really train my client on if they are going to be embarking on a mediation.
Thank you, Yanagi-sawa-san. Now, can I trouble you more? Because, sorry, Yanagi-sawa-san, I have another question for you, arising from what you just said. In fact, I'm going to tease out something which I thought was interesting from the mediations I had with the Japanese client. I thought it is extremely important to understand hierarchy from the Japanese client perspective, because if you have a junior person, even with full authority on one side, you're not going to get a settlement, because hierarchy plays a very, very important role in the culture. And I mean, to an extent, I mean, I've been to Tokyo, wonderful place. I mean, it's an amazing place to go to, my favorite destination for holiday. But when I'm going for a business meeting, in fact, even entering into a lift, there is an expectation as to who enters first and who enters last. So with that, maybe that's something. Sorry if I'm burdening you too much. Can you explore that with us a bit more on the hierarchy?
And I think that's a really interesting point. So I mean, even if a junior person who's been sent to the mediation table has been given full authority, I would not be surprised if he is subconsciously mindful of what his superior would say if I exercise my authority. So suppose he's given authority to settle for $1 million, and he agreed to settle for like 700,000. But I would not be surprised if in the back of his mind, saying what would the boss would say if I accepted this, and then I wouldn't not be surprised if he wants to consult his superior before actually biting the offer.
I see. I see. That's really interesting. Now I'll move on to the second question, which I have. And before I move on to the second question, just to give context to the panelists as well as those who are listening to us, we had the recent Alaska talk where the Americans went with gun blazing, and the Chinese went against them, and in an open forum. So it was nasty. But hopefully when the closed forum happened, it suggested that there were more constructive talks. And when I conduct mediations as well, or rather when I'm a mediation counsel, sometimes I do go aggressive on some occasions, depending on who the counterparties are. In terms of sometimes getting into the motivations behind why they are doing such. Sometimes it may be an attack on integrity, but at the same time, managing the emotions, the mediator has a tougher task at hand when such things are raised. So I appreciate it's all universal. Nobody likes to be called a liar. But at the same time, nobody also likes to be found out that they are a liar if it matter goes to court by way of cross-examination. So from a cultural perspective, how do you, when you're presenting a case which is emotive, sensitive, how would you deal with it? Maybe Ms. Varuna, are there certain things which you cannot say, should not say in the Indian context? No go, red line. If you say that, people will walk away and leave. I can't call someone stupid. So things like that. I mean, is there something which is a no go? Maybe Ms. Varuna, can you?
I can only talk of my experience of a no-go. There was this trademarks dispute, again a court annex dispute, where there's a big 300 million manufacturer. They were real brothers, and there was a trademark dispute between the two. And the younger brother, who runs his business from Delhi, he wrote a book about the progress. How did he build his empire? And in that book, he wrote Black Sheep of the Family. And the chapter spoke of the brother who was in Calcutta. So sad. So the whole thing broke down. We were on the verge of a settlement, and this book surfaced from nowhere, and the entire thing was on the verge of breakdown. So and though the chapter actually was not speaking about him, or the book which was published was many years earlier, and somehow it came to the table in the mediation. So a personal attack was very difficult to handle. They were walking away from the mediation, but as a mediator, I had to sit them down and in a roundabout way get an apology, and and then get them to the interestingly, as we were talking earlier, the matter may not settle completely, but the suggestions of the matter which was made during the process were incorporated, and there are no more disputes of trademarks left between them, though the litigation was left hanging. But yes, this was this is something, a personal, absolute personal remark which may surface from your Facebook or your social media or anywhere, can break it down. And in today's time, I think everybody the moment the matter is there, they want to find out the connections of the mediator, whom all does he talk to, whoever he's connected on LinkedIn and all that, So that is a very, very important thing in today's context. And see, India is a very vast country, and we have and culturally we are very different. Like South India, North India, Punjabis, and then state-wise. So we are very, very different. So as a mediator, we have to be extremely careful and staying away from the cultural aspect. We believe in that there are 4 communities which started the world, and so we have to stay away from referring to them like traders are called banyas. So, or the people who were the warriors were so they are referred. So they have some elements still there. So if you refer to them with that specific thing, that might play against you completely. They will not like to hear. So because it has a positive and a negative attached to it. So so you have to stay away from that. Then a very important thing is the language. English is not our spoken language, though we are very good at it. And so the moment we enter into a mediation and the parties come before us, first thing we ask them, what language are you comfortable with? So like I speak 4 languages, so I offer them that which language are you comfortable with, and for my own notes, I would write down which community, which place, everything, every detail, but for my own reference. So that when the mediation takes place, what can hurt the other person? Let me not give a commercial dispute matter. Let me give you a family dispute where there is a daughter is married into a different community, and the parties are sitting there for division of property. Okay, so anything that you say about that community can break it down. So one has to be really knowing a lot about the country, from which culture, which religion, which caste, which region are they coming from, and their language, what are they comfortable with. And then we have companies which are family held companies, most of them, other than Tatas, and so they are very possessive about their value and their culture, how they have developed them. So while we are mediating, one has to be very careful on that aspect.
Wow, your experience as a mediator is so helpful. I mean, especially coming from India, which is such diverse culture, and so I mean, it's very helpful. I mean, I've learned a lot just listening to you. Now, Yanagisawa-san, maybe this time can you answer these questions going second?
Okay,
In
sure.
terms of no-go.
I think this is probably maybe very typical of Japanese company, but obviously depends on the case and the strength of the merits, and whether this is a corporate client or whether it's a corporation but heavily influenced by its its founder. There's a different shades to this, but generally what's important when you have this kind of like a rehabilitative communication is an expression of apology to some extent. So I'm sure whenever you see some like problems arise from Japanese corporations, you always see their CEOs or whoever, the deputy to the CEO, saying, "I'm sorry." But they're saying, "I'm sorry," not exactly to the liability or making an admission, but they're saying, "I'm sorry for causing this trouble and for causing disturbances." And that, in my experience, that's been misunderstood by others as being making admission. But in Japanese context, I think if to the extent one party is more or less at odds in terms of the merits, then you kind of expect that some sort of an expression of feeling apologetic for the dispute to have happened. That could be I would call that like an ice-breaking apology. So that might be something interesting from a cultural perspective in Japan.
Amazing. I acted for Sojit on a dispute. It's an interesting one. And the opposite, and guess what? The opposite side were Korean, CJ. So one of the issues which was canvassed quite extensively was why in the world did my clients said sorry if they were not admitting liability. It was so interesting. Thankfully for us, the person who was adjudicating knew about Japanese culture, so he could follow through the arguments which I was making. That look, sorry doesn't mean an apology. Sorry means that this event has happened and it has caused a problem with our relationship. I am sorry that this has happened to both of us. It doesn't mean that I am wrong. It means that how do we go about trying to resolve this issue going forward? So thankfully, the person who was adjudicating was familiar with that conceptually, and we prevailed in that dispute. So it's what you just said is close to my heart. So I thought I will just express that. Mr. Lee, your turn now.
Yes. Well, as I said earlier, Korean parties run a high emotion. So when I mediate the case, I wouldn't let them say a lot of angry words. I strictly limit their comments on that. Otherwise, they're gonna run out of the room. However, I'm using a separate caucus a lot. In a separate caucus or a separate meeting, I will let them say everything. And sometimes I'm responding their angers. Why do I do that? Because number one, they were pouring out all the different hidden stories. So that is important. I can find out the hidden stories, number one. Number two is, this mediator, I can trust him because he let me say everything. So I can earn some credit for that. So during the separate caucus, I let them do everything without any limitation. I sometimes encourage them to say everything. So that is the one communication method I know. And I want to touch upon efficiency of a mediation shortly, because actually Mr. Bazul talked about a lot, but I'm going to give you a short experience. I was a mediator about the patent case because I'm a mediator to the patent court. So the person A is a patent holder. Person B is a manufacturer. Happily, they signed the joint venture agreement and they run the factory for 2 years, but now they are fighting each other very angrily. Well, when I listened to the case, each party didn't budge at all. Why? I found out that there are more litigations, A to B, B to A, not only the civil case, but the criminal case as well. There are 5 cases. So actually, I was referred to a one case, but the settlement cannot be reached with one case. So I went to the bottom of the case. And then finally, I could find out some way to settle all entire 5 cases. But at the end, still, person B must pay some money to person A. So on the last moment, I said, okay, Mr. A, would you accept this amount of money, not as a commitment to pay at the end of the month, but right now? And he said, is it possible? Yes, it is possible. Actually, he received the money through the internet banking on the spot. So I can seriously reduce the requesting money amount by using internet banking. Well, at the end of it, actually, the judge may not know it, what I did actually, because he's expecting one case settlement. But in fact, this party withdraw the entire litigation in 5 different jurisdictions, criminal and civil. So of course, it's not $1 million or multi-million-dollar case, but there are so many cases, person A, person B is fighting each other. But one of the enforcement efficiency in mediation could be, you can pay right now. If we can use that one more widely, perhaps it will be the most efficient dispute resolution scheme. Dr. Bazul?
Wow, Mr. Lee, I mean, it's so interesting. I mean, the ability to assess that there are other cases and wrap everything up. It's brilliant, brilliant sharing of experience. Now, Mr. Lee, I want to probe slightly further in terms of trying to assess the Korean culture. You know, I have represented Korean clients, and I've done that from the time I was a junior. You know, one of the, I thought, and I don't mean in any form of disrespect, I thought they're very aggressive initially. I mean, I couldn't quite follow that. And they want me to do massive damage to the other side. No concession at all, zero concession. They just want to go and destroy the entire the opposite party if that is possible. I thought it was interesting. When I was junior, I couldn't understand it. But when I was become more and more senior, I was able to pick this up. And I'm not sure whether this is correct, and I'm going to test it with you. What the clients were doing is, they were not trusting me effectively. They were not thinking that if I may think that they may be prepared to show some concession, they may be prepared, if I may be misunderstood, I may misunderstand, they are willing to compromise and take it as a form of weakness and compromise their case even further. So they want to give me the impression that they don't want a concession so that I will do my job as a litigator 100%, even though there is a risk that they may well end up losing a lot more. But they were not prepared to tell me that they were even prepared to compromise even 1%. They just wanted to give me an impression that they want to fight 100% so that I will do my job 100%. So is that something which is normal?
Well, yeah, that's an interesting experience. Well, small or large, I'm experienced a similar situation as well in a domestic mediation. But I think we have to approach in a two-way. Number one is that Korean people are highly concerned about what they look like to others, how others look at you. So if they make a concession, means that, oh, I did wrong. That's why I made a concession. So they want to avoid that. Number two is that in a corporate world, decision-making procedure is not that clear. So if I make a concession, maybe somebody in procurement department must get reprimanded because of that, or somebody must be punished because of that. So they want to avoid those corporate internal politics. So number one, they are conscious about what others think they are. Well, I even venture to have some kind of a so-called press release draft. Of course, the mediation is confidential, but eventually other people will know about this. Then how we can make a position about the case. So party A, party B can agree this much we're gonna release to other people about this case. Then save their faces. Nobody will hurt about that. And this one also applies to the internal politics as well. Internal politics, who can be punished in Department A, Department B. So in that case, perhaps we have to invite top decision maker. If usually sometimes the company people has a limited authority and they come to the mediation room, but eventually I cannot make a good mediation settlement. So I need somebody who can make a decision. not only the Department A, but also Department B, somebody who can control over both of the departments can make a good decision. And he's the one who have a balance between the a little bit of a concession will give him a much better benefit. Back to Bazul.
Thank you. Thank you so much. I mean, thank you so much. Very useful. I've learned a lot. Pak Dandi, you may want to have some more questions. I understand that you may have a question or two.
Sorry, I was still muted. So I think I think everyone want to ask this thing. So what is actually your recommendations for mediations to be successful? Because see, myself, I'm not a mediator, but I'm counseling a party to the mediations. But I want to understand from Mr. Scottley and Yanagisawa-san and Ms. Faruna, what is your recommendations for mediations to be successful? Maybe Mr. Scottley, your turn first.
I limit my thinking within the Korean situation. The Korea mediation is not widely used yet, but we have a potential. So I think we have to embrace some infrastructure, legal mechanism for promote the mediation. And it comes with the training and recruiting excellent mediators. And also it's a compensation for the mediators must be appropriate level. Then we can have a better mediation. Back to Dandy.
Okay, I think that's the very important thing. Yeah, training for the mediators, because like my presentations before, when we do the mediations led by an untrained mediators, then the successful rate will be very low compared to if the mediation is led by very well trained mediators. Yanagisawa-san, how's your view on the recommendation for the successful mediations?
Okay, so I think the situation is somewhat similar to Korea in a sense that Japan has not utilized mediation as at least a predominant common way to resolve business disputes. So in that regard, one, we need to explain what the process of the mediation, what's likely to be achieved, and what are the benefits. And more importantly, we need to set up an infrastructure. That's so in Japan, we established a Japan International Mediation Center back in 2018 in Kyoto, near temples to keep people calm down and have a nice way to make conversation. But not just the infrastructure, but all equally crucial are the trained mediators and councils advising on mediation. So those are the things that Japan is now working on, and I think I also agree, and I'm hopeful that mediation becomes a useful way to resolve cross-border disputes.
Thank you very much. Thank you very much. Ms. Varuna.
Yeah, so I would like to read here something. In the words of Gautam Buddha, better than 1,000 hollow words is one word that gives peace. And another thing, a Sanskrit shlok that says, Santosham Paramam Sukham, that anything that gives you satisfaction is which gives you the ultimate happiness. So whenever the parties that come for mediation, whether the matter is settled or it is not settled, they are thankful. Their emotions are resolved. The communication is established. They do not know what was happening in the opposite camp. Actually, there is a kind of war going on when there is a communication breakdown. So mediation is a process which brings a lot of satisfaction. So taking that as the background, I would suggest that when the companies are incorporated and the incorporating the authority should encourage to have a pledge in their incorporation that any dispute that will be coming their way should go for mediation. It should start from the inception of a company, that mediation becomes the way forward in case of disputes. Then there has to be awareness programs. Not only a lawyer can be a mediator. It should be specialized fields, like doctors can be mediators, chartered accountants can be mediators. And if there is a mediation that is happening and it is a subject specific, we should be able to have a team of mediators who can help in resolving the dispute. There was a matter where the hospital went on strike. And because of the doctors and the nurses on strike, patients were suffering. The Chief Justice stepped up and sent few mediators to resolve. And it was resolved in a day. And they went back to work. So awareness is very, very essential. Like I told you, that the national law universities are running programs for mediation advocacy, negotiation, and mediation. So we have competitions which are happening. So the next generation, which will be coming into the dispute resolution field, will not be like a dispute, and a court will not be the way forward. It would be, they will have a multi-door concept, that there is a dispute, which is the best way forward. So that kind of awareness programs are very, very essential. So that is, I think, a way forward
for
me.
Yeah, thanks for the insight and your wisdom, Ms. Varuna. Thank you very much. I don't have anything to add. Maybe Bazul, if you have anything, otherwise we can come back to Praniti for questions from the participant.
Yes, thank you, Mr. Dendi, and thank you, Mr. Bazul. We have a Q&A session for this panel discussion, and we already have some questions in the chat box. The first one from the Halashon SKF Sweden company. Does mediation always end up in court? Okay, maybe one of the panelists can answer from each country's perspective. Does mediation always end up in court? Yes, Ms. Varuna?
Yeah. So that was my answer for the first question, that they see, when the matter is at a pre-litigation institution, whether it is private or it is the court annexed mediation desk, then the settlement that is arrived at is a decree in itself. And when you are mediating, the parties have to be feeling so much for the process that they should not be running for execution, filing execution applications in the courts. They should be respecting the process to the extent that they should honor the settlement they have arrived at. So my answer is not necessary.
Okay. How about in South Korea, Mr. Scully? Does mediation always end up in court, or they honor the word or settlement?
Well, almost all the mediation in Korea is actually conducted with the court annexed mediation. So if the mediation does not bear fruit, and the case automatically back to the litigation.
Okay, thank you. And for Mr. Yanagi-sama?
Yeah, so also in Japan, mediation is almost entirely conducted in court, and the way parties can reach mediation can be twofold. So one, you can start with mediation, then end up going in court, or you can start with the litigation but have the court referred back to mediation. So in the first case where parties start out as a mediation, it's up to the parties whether they will continue to the court in case the mediation fails. So in the latter case where the litigation's initiated but the court refers it back to mediation, and in that case where if that's the case, then the litigation will be stayed pending the outcome of the mediation. And if mediation is successful, that's the end of the case. But if mediation fails, then it goes back to litigation.
Okay, thank you. And Mr. Dendi, how about in Indonesia? Does mediation always end up in court, or is mediation a word or isn't enforceable, or?
Yeah, I think it's similar to what Yanagasawa sounds explained. It depends on what type of mediation is proceeding. For example, if the mediation is part of the mandatory mediations ordered by the court, then of course, if the mediation succeeded, then it will be considered as akta vandading or settlement agreement. The status will be final and binding. But if it failed, then we'll continue with the proceeding. But if the mediation arbitration, so the mediations, the settlement agreement will be considered as a mediation, will be considered as the arbitration decisions. For the execution, we have to obtain a court order for that. I think that's the answer.
Okay, thank you, Mr. Dendi. And Mr. Bazul, how about in Singapore?
Well, it doesn't often end back in court because there is a higher rate of settlement. So parties settled and keep to their settlement. So that's my experience.
Okay. And the next question is to Mr. Bazul Ashraf. There is a basic question I'm wondering to ask is from Tiara Rizky Febrianti. How if one of the parties doesn't follow the rules or the mediation result, how the mediator could take action at this point?
Yes, so it's a good question. The mediator needs to be active. So as Scott Lee said, if there is the open forum is becoming a raucous and parties are at warring. So what, as Mr. Lee said, you can then break parties into private caucuses. And then you take control of the private caucus as a mediator. Don't put them together. So that's the answer to your question.
Okay. Next question. Is there any way that the mediation can have a definitive timeline to close the mediation, either successfully or not, without it dragging for years? It's from GA. Maybe from Mr. Bazul can answer. Is there any timeline for mediation proceeding?
Of course. I mean, as Pak Dandi said, in Indonesia, there's timelines. Parties can set the timelines, agree to the directions, and you can complete it within a month, as I said in my speech as well. So no, it doesn't drag on. Mediation doesn't drag on, unlike court proceedings. Because court proceedings, the control, the timeline is with the court. And some jurisdictions you have overwhelmed by the number of cases, so court cases don't move as quickly as they should. So in mediation, it's within parties' control. So yes, you can set strict timelines.
Okay, thank you. And for Ms. Varuna, is there any mediation timeline in India? Mediation proceeding timeline? Specific time period?
Yes, the mediation timeline is 60 days. First 30 days, and then if there is some, you feel that yes, mediation can be settled, then you can send back and take another 30 days time, and 90 days is the upper limit for the settlement. Or if the file is to be sent back, it has to be concluded in the court and next mediation within 90 days.
Okay, thank you. And for Mr. Yanagisawa,
So if
is there any mediation timeline?
So if it's
or
a
is
court,
up to the parties?
if
Okay.
it's a mediation conducted by the court, then the law does not provide any specific time limit. Although after several hearings and caucuses, and if the mediator decides this case is not suitable for settlement, then at their discretion they might end the process. But there is no fixed hard stop time limit on this.
Okay, so there is no time limits for the mediation proceeding. Okay. And Mr. Scott Lee, how about in South Korea? Is there any specific timeline or time period for mediation proceeding?
Yes, from my experience, well, like a 2 hours a session, and you have a lunchtime and afternoon, or afternoon 3 hour session, and the next morning 2 hour session. I think that is most effective. If you have another one 2 weeks later, another one 3 weeks later, from my experience, it does not as highly effective at all. So I try to focus on the given time, and if there is some chances of circumstantial change, because the party A say that I have to wait until situation is developing such and such, then in that case we can decide the second session for in 2 weeks. Otherwise, we have to sit down and find out some solution.
Okay, how about in Indonesia, Mr. Dendi?
Yeah, in Indonesia, like I said before to the presentations, if the mediation is conducted as a part of the court mediations, then 30 days subject to another 30 days extensions. But if it is privately led mediations, then it's subject to the agreement between the parties to agree on the time frame.
Okay, and the next question is,
Can I just, Praniti, can I just
Yes.
say something? I mean,
Yeah.
so that there's no confusion. If the question is also meant to ask how long after the mediation hearing starts, how long does it last? If that's the question, my own personal experiences is that of Mr. Lee. It's usually 1 day, maximum 2 days, but you cannot drag on a mediation. If you allow that, parties will take positions and they will never settle. So you need, and usually also my experience is only at 6 p.m. will the real offer comes up to the table. So I thought I might as well say that so that there's no confusion.
Yeah, and if I could just speak from my experience, the
Yes.
most driving factors why parties mediate is because they want to settle and go home at the later night.
Okay, thank you. And the next question is, maybe it's for Mr. Dendi. If a corporate in Indonesia have dispute with other country, how the completion process mediation between two country? There need the minister from each country. Maybe that's if the two corporate company has a two different jurisdiction.
Yeah, I think it depends on which jurisdictions that you will enforce the settlement. If you want to enforce it in Indonesia, then you have to register it in the Indonesian district court where the court settlement will be enforced. Yeah.
Okay. Maybe.
Just one second. I just wanted to, suggest a small little thing which I faced only last month. I just wanted to share it. See what happens in when there is a 30 days process or a 60 days or a 90 days process. There are times parties to take advantage of it. There are, they do not disclose the matters that they have filed, and they might just, delay the process of mediation and achieve some adverse order against the other party. This was my very recent experience, and after that, the only way to prevent this kind of situation was to get it on table that what all litigations have been filed by either of the parties, they should disclose it at the initial stage itself. That was a very where I felt that the mediation process was wrongly used.
Okay. Maybe Mr. Bazul can add something. If there's two different jurisdictions, how can you settle in SIMC maybe?
Yeah, that's interesting. Very good question. SIMC, in fact, was put together to deal with disputes involving two different jurisdictions, multi jurisdictions, in fact. So, what SIMC does is it appoints a mediator who is well trained and who is familiar with the cultures, as well as the enforcement mechanisms as well, because that's also useful. So then the next thing to do is once a settlement is reached, the idea is how would the settlement be enforced? So there are certain jurisdictions which will not allow you to open the settlement as a question of and reopen the dispute on the merits. There are multiple ways to deal with it. One way is to enter it into for example, a Singapore court judgment, if assuming it's done in Singapore. Once it is a Singapore judgment, if assuming there is a dispute in Singapore, then that judgment can then be enforced as by reciprocal, if there is a treaty, by Hague Convention. So there are various means to enforce the judgment. And assuming the Singapore Convention is taken up and by multiple countries, that's another route to enforce international cross-border mediated settlement.
Okay, thank you. Maybe Mr. Scotley can add. Have you ever experienced that there are two different jurisdictions to settle in mediation in South Korea?
Unfortunately, I have no personal experience of a cross-border mediation yet. And as I said, the mediation is not widely used in Korea yet. So yes. I'm hoping, I'm very happy to join this vibrant activities about the cross-border mediation.
Okay. Mr. Yanagisawa-san, is there any two different jurisdiction disputes?
Yeah, I mean, I guess I'm kind of following the same footsteps, but Japan has not enacted a legislation to adopt the Singapore Convention, which means the mediated agreement, the enforceability of a mediated agreement is uncertain. The government is now trying to enact a legislature where to make that happen. And once that becomes a legal infrastructure of a country, then I'm expecting more cross-border mediation to take place.
Okay, thank you. And the next interesting question is how to convince the parties to take the mediation settlement other than arbitration and litigation. Maybe we can start from Ms. Varuna. How can we convince that mediation is an effective way to solve the dispute?
Very important, three things in mediation. One, it is time bound. Two, it is cost effective. Three, the parties are in control of the outcome. In no other jurisdiction other than negotiation, mediation, and conciliation, the parties are in the control of the outcome. So I think of course, execution is another very important thing in this. So if it is a court-annexed pre-litigation mediation, so execution is not a difficulty. And if it is a private mediation, then it is a conciliation award, and it becomes a consent decree, and again it is helpful in execution. So I think when you see that there is a sure outcome in sure time and in a cost-effective manner, the parties will be very happy in participating. My take would be that whenever I speak to the parties and make an opening statement, I think this is what I talk to them about, that you are in control of the outcome.
Okay, and maybe Mr. Scotley can add how you convince that mediation settlement isn't effective considering the culture, South Korean culture.
Yes. Well, one of the case actually, there was a patent fight, and it was a very lengthy fight. but somehow we settled. So you're gonna make a product and sell in a particular area only. Look, if they fight at the court, can you make arrangement like this? No way. Somebody win, somebody lose. But we draw a line. Okay, you're gonna make a product and you're gonna sell this area only. All right, that's a good thing. But the parties will ask me, what if he's violating the gentleman's agreement? Then I would say, okay, let's put the penalty articles. All right, once you find out that guy is selling the product here, okay, let's charge $500,000. Of course, this is a gentleman's agreement plus penalty articles is a very, very strong article to ensure the execution of the settlement.
Okay, penalty and indemnity articles, such an interesting way to solve and to convince the mediation settlement to the client. Okay, Mr. Bazul Ashab, maybe you can add how you convince, based on your experience, how you convince your client to settle in mediation.
I'll use WATNA, which is what it means is worst alternative to a negotiated settlement. That scares people. Even the word WATNA scares people. So, what it means effectively is, if the alternative is terrible to a negotiated settlement, for example, depending on the case, if it will destroy relationship, and relationship, there's a value to it. If the cost is substantial, if you are looking at several $100 million litigation, which is spanning, or even an arbitration, which is spanning for 2 years, I think the cost will easily be $1 million, $2 million. So cost can get scary. After a while, your principals may have to give up to cost consideration. Thirdly, delay. There are certain jurisdictions, which may take 15, 20 years to get matters resolved. I have a matter which is still continuing in Dhaka court. I started that when I first came into practice. I inherited that file. That's about 20 years, and it's still going on because the client transferred the file to me. So what's the point of getting a victory when the assets are no longer there, no one is there? So WATNA is a good way to scare people.
Okay, unfortunately, our time has come to an end because the companies told me to stop the Q&A session, and the rest of the questions will be sent to your email, and the participants can ask directly to the panelists and the guest speakers. And Mr. Bazul, you can give your closing remarks or closing speech for us for this public webinar event.
Yeah, sure. I mean, I'm going to keep it extremely short because I think this has been extremely useful. Speaking for myself, if anyone thought that I'm going to come here and share my thoughts and that's all I'm going to do, that's really not what happened. I actually learned as much as I gave. The panelists were amazing. Pat Dandi, the Indonesian perspective was informative. Ms. Varuna, the Indian diverse cultures and what takes place in India, is as very educational. Mr. Lee, Yanagisawa-san, the cultural elements one needs to look at, again, was enriching, enlightening. So I have learned substantially. And on my part, although the poll suggested that there are still some persons who are not convinced in terms of the the effectiveness. But if you look at it from the percentage point, yes, it seems to be high. But if you look at it from the number of persons, it's very low. I think as panelists, we have done a wonderful job in moving people. It looks like there are only 6 persons who have said that they still feel that it's ineffective out of hundreds of participants, which is not a bad, outcome to have reached as a panelist. So I'm delighted that as a panelist in total, we have convinced people to mediate. I believe that mediation is in the interest of clients, and it is in those who are participating in this webinar, and in-house clients, lawyers, think about mediation as a useful tool. And you can approach any one of us as in the panelists. If you have any further questions, we will be delighted to speak to you more. And I hope that you enjoyed yourself as much as it was informative. It was fun for you as well, especially as speakers. And in fact, we were chatting about this. There was a risk that after lunch, people may not be as attentive to a webinar, especially a Zoom webinar. And I hope that we managed to keep your attention on what was discussed. Thank you very much for participating. I have nothing further to add.
Thank you, Mr. Bazul. And now we are ready for the photo session. And for all the participants, please turn on your camera. I will be okay. The Kabadis will take a picture for all of us. Now, for the first page, say cheers. Okay. Maybe for the next page, say cheers. For the third page, okay, and for the fourth page, and the last page. Okay, thank you for all the participants.
Thank you very much.
Yes, and we will be sharing a G form, and please fill it out. Maybe you can check the chat box. The Kabadis has shared the evaluation form. Okay, for all, thank you for joining one of the biggest international public webinar event held by Asia in collaboration with ADCO Law Indonesia and Oon Bazul LLP Singapore with theme Mediation, a tool to resolve business disputes in a win-win mode. And today we are extremely fortunate to be able to participate and involving 5 amazing guest speakers from 5 Asian countries: Indonesia, Singapore, Japan, South Korea, and India. Thank you for attending and thank you for joining. Hope those informative explanation from each speakers can help to resolve your dispute from mediation salon. Thank you.
Thank you.
Thank you, everyone. Thank you,
Thank
Pak
you.
Bazul.
Thank you very much. Very
Thank
nice.
you, Mr. Selvi.
Thank you so much. Bye-bye.
Bye.
Bye. Very nice webinar, Varnadi.